It is Thursday, and that means it's time to get a take on the news from the left, right, and middle. From the left, Arise News contributor Wallace Ford. He is a political blogger and professor at Medgar Evers College. And from the right, Horace Cooper, who is a legal commentator and fellow at the National Center for Policy. Good evening, gentlemen.
Good evening.
Good evening.
How you guys doing?
All is well.
All right, let's jump right in. I think no one will be surprised that I'm going to bring this up with the two of you, and that, of course, is the email account that Hillary Clinton used when she was Secretary of State. We know now that she used her personal email account from a personal server. So here's my question for you two. Did she violate the spirit and or letter of the law? What does that mean? Is it a big deal, or is this just the right creating sound and fury over nothing? Wallace, I think I'll start with you.
Sure. I can't say whether she broke the law, but I can tell you, having served for 2 New York State governors as a senior official, as well as the Mayor David Dinkins in the city of New York, that one of the things that you learn, of course, particularly in senior levels of government, is that this whole notion of freedom of information is extremely important, which means that, of course, you have to secure that information. If you just throw it out every time, then the law would be pointless. And so when you have with Hillary Clinton here, and this is really a concern, I would think, is that with the private email, with the private server, that there's, even though she's communicating with people with government accounts, that obviously the spirit of what the Freedom of Information laws entail is not being observed here. Now, let me just go real quick and just say, having said that, I don't know that it's that big a deal, because whether we're talking about Dick Cheney or Scooter Libby or Karl Rove during the George Bush administration, and I'm sure we'll see this going forward in other administrations, Democratic and Republican, people will use their personal emails. And,
okay. All right, I'm going to call time on you. Yes, Horace, what are your thoughts?
Well, I think Wallace has laid out a fairly straightforward analysis of this situation. I don't know yet that there is a reason for us to conclude that a law has been broken. I do think that the transparency rules would expect us to use our official email accounts, and it's in a good way for us to be accountable. On the other hand, now that she hasn't, I'm a little troubled and reticent to say that we should send a committee staffer to look at all of her emails, personal and private, to figure out which ones we want. If it gets to that point, I'd be open to recommending some sort of neutral individual, maybe a retired judge or someone,
Pope Francis,
to try to figure out which ones are relevant and which ones are not. Yeah. But it's not clear to me yet we've reached a point where this is, quote, a crime. It just isn't the kind of thing that you'd want if you're saying, I want to be above board and as transparent as possible.
Well, you see, the thing about it is that the personal server part is what really gets me. The personal server in your home, it's a little different from, okay, sometimes you might use your personal email, sometimes you use the other phone, you use the government email, but that personal server says that there's something, there's an intention really to just, I don't want everything that I'm doing to be known and made public. And then they've released 90% of the emails, but we don't know what the standards were for that. So again, having said all of that, I don't know that there's some big smoking gun. The Benghazi committee is already revving up and saying there must be something about Benghazi. And I don't think that's the case. I don't think it's a big deal. And if we're going to make it a big deal, then it's a stone that's going to hit a lot of glass houses.
Yeah, I think it becomes a big deal if there's something in those emails that will be discovered now that they're being released that could be related to Benghazi or anything else. So maybe it remains to be seen. So we'll leave that there for now. So let's move on to our next topic. Of course, we know that the Department of Justice has been investigating the practices of the Ferguson, Missouri Police Department, as well as the city government and the municipal court there. The Justice Department has not released their report, but some of it has been leaked. And there were these really grand biases that have been found in the policing of the Ferguson community by the Ferguson Police Department. That's a big, long preamble to say this. Horace, I'll start with you. Should the police department and or the city be sued by the federal government?
Well, it's not clear to me yet that the evidentiary level has been reached to justify invoking the provision of the law that allows the Department of Justice to take over a police department or to enter into a involuntary decree over their activities. What I do find interesting is that the Justice Department revealed that, in fact, most, if not all, of the people who claimed that Michael Brown had raised his hands, had attempted to surrender, was shot in the back, was running away, was not in fact true. And in fact,
that's not what it said, Horace. They didn't say it wasn't true. They said there wasn't enough evidence to support it. Please, you're entitled to your opinion, but not your own set of facts.
The FBI agents themselves said that those witnesses recanted. Only a few stood by their original statements. The lion's share of them recanted.
And in addition to that, just to be really clear, as I understand it, what we know so far about this report is that the testimonies were not reliable, that there was not consistency in that testimony. But Horace, that's actually not what I asked you about. It was about the practice of the law.
What I'm saying is, we have an evidentiary record that is not the basis that the Department of Justice is normally allowed to use to force a police department to change its practices. You actually have to show particular instances, such as a Darren Wilson incident where someone was shot because of racial animus.
You're also allowed to look at patterns and trends. 67% of the population of Ferguson is black. 87% of the arrests taking place in Ferguson are of African Americans. 90% of the use of excessive force against citizens is against African Americans. You can, in fact, use those numbers, use those statistics to cite a pattern. But one thing I just want to say, Debbie,
cite a pattern.
Yeah, there's a pattern. Yeah, but
you can cite a pattern. You won't win in court.
Okay, well, I guess we'll just have to see. That's always the case. That's why we have courts in the first place. But let me just say this, and I think it's an important point to keep in mind here. I don't know that a Department of Justice headed by an Attorney General who was appointed by, quote, President Mitt Romney would ever have issued a report like this in the first place. And that's why elections do matter. Now, having said that, I think that what we see in the Ferguson situation, and you know that's true, Horace. You know damn well that's true.
But there was never any reason for the investigation to start with. The Department of Justice concluded it. The local attorney concluded it. There was never
a Romney administration wouldn't go near this in the first place.
There was never any reason for the investigation.
Do you really believe that? You really believe? You see, because the statistics I just cited with respect to Ferguson, Horace, the statistics I just cited, that's not. Ferguson is not an outlier. Ferguson is not an unusual circumstance. There are Fergusons all over the country.
Okay, hold on, because I want to hear what both of you are saying.
Yes, Horace.
Okay, Wallace, you got like 20 seconds. Finish your thought, and then let Horace respond.
There are Fergusons all over the country. We just happen to see this one investigated to a greater extent. But whether we're in New York or whether we're in Los Angeles or all the small towns, villages, and counties around this country, what we do know is that the law enforcement system has been used to perpetrate various racist and racially based bigoted activity, and this is something it needs to be addressed, and it's not just in Ferguson.
Horace, go ahead.
An exhaustive investigation by the FBI and by the grand jury in that jurisdiction
let's not talk about the grand jury now.
Demonstrated that this incident did not happen. There was no person gunned down who was attempting to surrender. There was no hands up. There was none of that. And in fact, they have overwhelming evidence that DNA was found on the collar, on the shirt, and in the interior of the car, consistent with an attempted attack.
I'm a little confused that why you're muddling the two, because there was an investigation into whether or not Darren Wilson violated the civil rights of Michael Brown Jr., and they found that there was not enough evidence to bring charges. And that wasn't really what I wanted to talk about. It was really about the well-established biased practices of the police department and their collusion with the municipal courts against the citizens disproportionately who are African American in the city of Ferguson.
You can't build this home on a foundation that's based on fraud. The truth of the matter is, the fraud is there was no unlawful shooting of Michael Brown, and that is not any evidence.
Unfortunately, we're all out of time. But what I will say is, what we do know is that Wallace stated that the arrests were disproportionately higher amongst the African Americans, much higher than their percentage of population.
will not win in court.
Okay. All
Okay,
right.
and that's
Horace
why they
Cooper,
have courts, Horace, as we
Cooper,
well know.
Wallace Ford, down, guys.
Stay well.
Thank you.
All
We'll
right.
see you next week.
Stay warm.
You're watching Arise America. Whew.